So another case, and again, it's worth having a look at these cases. We've got another little bit in, out, and shake it all about as regards the orders being passed, revoked, amended, and everything. But in the end, the point of principle is upheld. That it shouldn't, but equally the UK hasn't given in on the principle that it could. Prison Board case has, and you'll find it in the Jersey and Guernsey Law Review, a repeat of the argument put by Haldane, who's a very, very famous and distinguished lawyer, I think later Lord Chancellor, who set out the Jersey's case as to why the Privy Council couldn't legislate. And again, you just kind of wonder why on earth it's doing it. For the prison board in Jersey, and who should preside? Should it be the bailiff or the lieutenant governor? So I suppose that's the answer. It's a question of whether it's a local administration or someone who's basically in the local administration or local officer, which is the Privy Council, the bailiff, as opposed to someone who is very much in the Crown side, which is the lieutenant governor, who is of course a representative of the Crown. The question is one of state's consent. And points that Haldane make are very, very important. The Campbell and Hall point, now I'm fairly sure that spelling error I've got from Philip Johnson. That isn't one of mine. Campbell and Hall, which is that when we've got a local legislature, then that must mean that Parliament has given up its power. So Jersey was an adult legislative assembly. The monarch now had a limited constitutional role. It's very interesting to have arguments like that being raised in the 1890s, and I think it was more or less Canada was, I suppose, the only of the countries in the empire to which that would have applied at that particular time, not having given it a constitution and in the British North American Act of 1867. Okay, that it wasn't that the Crown could not have retained its power to then legislate and pull rank. Of course, that actually said nothing about the power of Parliament to pull rank, of course, which I think was only totally abolished in Canada in 1981. Long hasn't kept up with Canadian constitution. Daniel's case, again, this is a bit of a from out of left field, because the royal prerogative of mercy tends not to follow the usual rules. So there would have been a prerogative of mercy in the Duchy of Normandy, and that prerogative would surely have devolved upon the Queen. Now, much, of course, depends, when you think about that sort of use of prerogative, who actually has the ear of the Crown? And the answer to that is the British government. Because when you ask yourself, why is it that Jamaica is entirely independent of the UK when it has a governor appointed to represent Her Majesty the Queen, exercising the royal prerogative in Jamaica? Why is that very different from the exercise of the royal prerogative in Jersey and Guernsey? And the answer is because the government of Guernsey does not advise the Crown on the use of its prerogative. It's still the British government. The Chief Minister, as was the President of the Policy and Resources Committee, does not even notionally have interviews with the Crown to the Queen to advise on such matters. It's not part of the Privy Council to advise on such matters. And I think that's a very, very important point.
Can you say that again?
Very important point, though.
A lot of
the point about the Guernsey
have they applied?
Well, if you start with Jamaica, okay. Well, the prerogative power in Jamaica, as in Australia, as in Canada, is exercised on the advice of Her Majesty's government of Jamaica, of Australia, of Canada. We in Australia would have a talk about Gough Whitlam and his sacking in 1975, but we needn't worry about that. But what it's never done is exercised on the advice of Her Majesty's government in the United Kingdom. When the Queen is Queen of Jamaica, she might as well be Queen of Jamaica and only Jamaica. So the Governor in General in Kingston, Jamaica, is never going to act on the advice of the British government. When the royal prerogative, whether that be the royal assent or any other use of power, royal power, power descended, as stated by the 1861 commissioners, from the powers of the Dukes of Normandy, whenever that is exercised by Her Majesty the Queen, it is exercised on the advice of the Privy Council. And that is the Privy Council of her as Queen of the United Kingdom, for these intents and purposes. Or other committees of it staffed by people who are there because they are ministers of the United Kingdom government. Neither the Chief Minister of Jersey nor the President of the Policy and Resources Committee have any role in that. Well, no control. The input to the exercises in forms of representation, and input to the exercise of royal assent to a law is in actually having passed the law. But whereas nobody advises the Queen, for example, to give her royal assent to an act of Parliament, because it's not as if there's a decision there to be made. There is a decision there to be made as regards legislation from Jersey and Guernsey, and the people who advise on it are UK people. So therein lies why the continued existence of the royal prerogative in Guernsey leads to power being held by the authorities in the United Kingdom. Now, one of the articles that I gave you was one of my articles, and I think I go into it at rather pedantic length. That's the summary. I don't think I've amended these slides enough in terms to actually deal with that directly, but it is in the I think it is in the study guide, and it is in that particular article. Now, Kilbrandon says that the power to legislate has fallen into disuse, and so it's no longer available. So essentially, it would be just grossly unconstitutional to suddenly start legislating directly in the name of the Crown. Now, the Home Office didn't accept that this meant that it could never be used. So they said, never say never. A bit like standing for more than two offices in the more than 2 terms as US President in the 1930s and 40s. It was never been done before, fallen into disuse, but it could be done. But what almost certainly can't happen is for the prerogative to be extended. We've gone past the point when the courts would oblige their royal master by recognising new prerogative powers. Now, the Civil Commission is in 1861, civil commissioners in 1861 addressed how Acts of Parliament apply in Jersey and Guernsey. And obviously this time it does say Jersey because it's the commissioners to Jersey, but everything they say could apply equally to Guernsey. If the whole of the Act in terms includes the relevant Channel Islands, it is obligatory by its own force without registration. Now, this is a statement that Parliament simply has paramount power in Jersey and Guernsey. There was no step required in Jersey and Guernsey to give it any sort of force of law.
So how does that fit with registration?
Registration was done as a matter of courtesy and convenience and for the information of the people in the Channel Islands. So if you had an Act of Parliament, registering it in the Royal Court made it clear to the islanders that it was part of their law. Which of course is important from a rule of law perspective because law should be published.
But if you had a situation where a law is made in England, but it's not registered, it still has force.
On this view, if you have an Act of Parliament and it says this Act shall apply to Jersey and Guernsey, then registration is not required. On this view. So,
Are we elaborating on that?
yes.
Okay.
The view changes.
Yeah.
Well, actually, it's
This is the view in 1861.
that's a view in 1861, and then there's something that I wrote a few years ago on that particular point. And as soon as you write something, it gets published, and then it suddenly your opinion becomes important because someone's published it. So anyway, if only part of an Act applies on its terms of the Act to Jersey and Guernsey, then the Ordering Council will only extend it to that extent. If an Ordering Council is used to extend an Act of Parliament, which is a more usual way. But if an Act isn't applied to the Channel Islands, it's still possible for an Ordering Council to extend it, but it applies by reason of that Ordering Council alone, and therefore is subject to all the limitations of a use of an Ordering Council. Because you're not using the sovereign power, it's not backed by the sovereign power of the UK Parliament. It's not backed by any concept of Parliament having paramount legislative power in Guernsey. If actually it's purely a choice of an Ordering Council to extend particular provisions, it might as well be an Ordering Council that's written out an Act of Parliament. Does that make sense? Okay, so this is the Group 1, Parliament to the islands. Do this. Okay? Right?
Yeah.
To Privy Council. Tell the eyes to do this. Okay, that would have been the scenario essentially with the sanctions and anti-money laundering bill. So it's basically telling the Privy Council to pass an Ordering Council. Very technical arguments you can make about it. Okay. Parliament to the see. You may tell the eyes to do. Okay. So there, they're giving, as a permissive extent, it's permission to extend an Act of Parliament. So you still there got the authority of Parliament saying this can be law. So it's kind of a middle ground between whether it's been, and we'll get to this because Philip Johnson raised it, it's in the middle ground as to whether this is actually really an Act of Parliament or whether it's actually a choice of the Privy Council and therefore subject to the limits of orders in Council. And 4, which is PC, PCI, do what is in. So there, Parliament hasn't actually said anything about the Channel Islands, but Privy Council is saying to the Channel Islands, by its order in Council, do what's in that Act of Parliament. And that is clearly an order in Council and not an Act of Parliament, because Parliament's authority is not involved in the fourth one. This one is definitely involved. This one is using its authority, but actually potentially weakening it, because by doing it through the form of Privy Council authority, so it's harnessing the Privy Council's authority, and therefore arguably subject to the limits of the Privy Council's authority, except that the Privy Council, as a matter of English law, has no right to disobey. But that says nothing about its position in Guernsey. And Parliament to Privy Council, you may tell the Channel Islands to do that. That's another intermediate position, much weaker in terms of whether it's the use of Parliament's paramount legislative power.
Do you have examples of when they use the different or is it really a matter of politics, or what the issue is, what the law is as to how they then invoke those policies?
Well, the Anti-Money, sanctions Anti-Money Laundering Act has an aspect of number 1 in terms of dealing with the regulation of waters as an aspect of it, I think. So even that's arguable. But generally, it doesn't do it directly. What you will almost invariably find is it's like this.
Sorry, the practical difference between 1 and 4, in a situation where the people in the Privy Council saying do what's in the Act of Parliament are essentially real.
Well, the difference is that number 4 would be a pure use of the order in Council power. So that would be subject to the same issues as the Victoria College case. It would be like it's passing the Victoria College style order in Council, only copying the words in an Act of Parliament as to how to do something.
So it's the Privy Council saying we think this Act of Parliament is
a good idea, and we think you should do the same, which is a pure use of the prerogative power and order in Council. Whereas number 1 would be a pure use of the purported paramount power of Parliament.
Did you labour use 4 for the capital punishment?
No, what it did is it arm twisted. It basically said we'll use 1.
Right.
We'll use 1 unless you do it yourself. Yeah, I mean the reality was, and it comes back to the Daniels case, that there was going to be no, even if there had been anyone sentenced to death, that the prerogative of mercy would have been used, as happened in the 1990s, I think, in the Isle of Man, of a contract killer, who was the last person in the British Isles to be sentenced to death. But it was always on the advice of the Home Secretary, going to be commuted as it was commuted. I mean, it wasn't a case where there was any doubt as to doing it.
So in 4, practically you would get the Privy Council saying to the Channel Islands situation, we think this Act of Parliament is a good idea, you go away and draft it.
No. What it's basically, no, sorry, what it says, this is actually, when I say tell them, I mean, it's not saying, could you please do it, sir? It's, you legislate. So the order to do this is actually the legislative, is actually the enactment, the law that says this is done. I didn't mean as in, would you kindly do this, or do this or else. It's not. This isn't about political effects. This is about. I meant it about the creation of law. Yeah. So see, and okay. I'm going to take that away and put it in the notes for next year, I think. Is it useful? Put it in the notes for revision. Okay. Now, this case, which was never properly argued from 1960, it's useful because it showed that the Royal Court in Jersey simply accepted the concept of the paramount power of Parliament. As of 1960. Okay. This was all to do with the Bankruptcy Act. The Bankruptcy Act extended to the Channel Islands and the Isle of Man. I mean, on the number one, another example is the 1848 Act of Parliament, which deals with extradition between the Channel Islands and England and Wales to do with recognising warrants issued in the two places. So you can be arrested in the Channel Islands on a warrant from England and Wales and taken back, and vice versa. What's not really known, little known, is that actually there was no extradition between Channel Islands, because no one's actually legislated for. Although I think Guernsey's legislated to hand people over, but that's something was discovered at some point, some act that had been forgotten about. Now, there's an argument recently in the Royal Court about whether that sort of principle in Bristow, whether the Royal Court and Jersey still blindly accepted the paramount status of Parliament, and it was argued by the then Attorney General that it shouldn't apply, and there are certain technical issues around the States of Jersey law which you needn't worry too much about, partly because they're not clear enough to actually abrogate the principle of paramount sovereignty of Parliament if the principle exists. But it recognised that things have moved on. In particular, there's the Matthews case. The Matthews case is to do with Gibraltar, and they're very proud of it when I first moved to Gibraltar, because they'd won a great victory against the UK and against the European Union, because Gibraltar is part of the European Union, as opposed to the Channel Islands and the Isle of Man. And it's subject to much more European legislation. And therefore, Mrs. Matthews, who was essentially put up to it by the Gibraltar government, made a complaint, which was, I am not allowed to vote for these, in respect of all these laws that apply to me. This is wrong, this is undemocratic. Article 3 of Protocol 1 to the European Convention says I should have the right to vote, therefore we should have the right to vote in European elections. And the European Court of Human Rights said that was absolutely correct, and she should. And Gibraltar was enfranchised in the European elections, which is why there is a constituency of the southwest of England and Gibraltar, and why Gibraltar voted in the referendum. Obviously, some legislation in Jersey, the European legislation does apply to Jersey, Guernsey, and the Isle of Man, but much, much less of it. And actually, all jurisdictions try to argue that there's actually a very minimal amount actually applies. And it would be very inconvenient if somebody went to the European Court arguing a massive amount of legislation applied, and therefore could we please have a vote as part of an English constituency. The rule of law issue. Unregistered laws are like unpublished laws, so shouldn't really have effect. So this was raised by the Attorney General and just noted by the court, slightly sympathetically, but not really considered. It's very much laying down a marker. Now, Kilbrandon dealt with the scope of the power to legislate, and here we begin to suffer a little bit from taking the various slides out of order, because we touched on this yesterday as regards the power to pass laws within Guernsey itself, and whether or not there are any limitations. There's an obvious overlap here. Now, Kilbrandon said, well, defence is obviously something that the Channel Islands can't legislate for. Matters concerning people around the world, or the British people around the world, succession. Well, we now know that succession can be legislated for by Guernsey. The interests of the islands. Well, as the UK is responsible for Jersey and international law, the argument goes, therefore the UK must be able to legislate on international law matters. International responsibilities. And then there's a difficult one. So it says protection of UK's domestic interests. Now there's a bit of incoherence within the Kilbrandon report, because it's not really, because the limits are meant to be to deal with good government. And it's not made entirely clear whether he contemplated the idea of the United Kingdom simply legislating because the government thought it would make things better in England. But you can very well see that if you had some Guernsey legislation that was an all-out attack on UK commercial interests, that the UK might be able to say, hang on, this is a very bad thing. You want all the advantages of this relationship, but yet you're being terribly awful to us. You want the advantages of us spending money protecting you and representing you on the international stage, but you also want to be a snake in the grass. So that sort of perhaps extreme aspect of really the UK's domestic interests, which were under consideration then. But of course, you get in the anti-sanctions, anti-money laundering bill a much broader approach to it being taken by the backbenchers, who say, well, if you want to be part of us, you have to subscribe to our values. And what they meant, in the case of Andrew Mitchell and Margaret Hodge, as regards UK values, was whatever is the current UK ascendant view on beneficial interest. It wasn't really a matter of long-standing fundamental values. It was an issue on which international opinion actually still divides. But you could see there the potential for it to be, well, if we say it's the right thing to do, then you should do it. If it somehow helps us for you to do it, which is a complete denial of the concept of autonomy. So the big name to remember in terms of challenging the UK view is Professor Jowl. Jowl is the director of the Thomas Bingham Institute of the Rule of Law, at least certainly he used to be. He's one of the most important constitutional lawyers. He's a regular advisor to the government of Jersey. I don't know how much do you use Jowl? Sort of bring him in when a big name, a big hitter is required. In his own writings, he's not terribly keen on parliamentary sovereignty. He can be a bit of a maverick at times, but he's certainly one of the biggest and most respectable names, and very useful for Jersey has found it to bring him forward. He's also advised, I think, advised the Caymans, I think, or possibly Bermuda, on sanctions and anti-money laundering bill. And what he says is, well, it's all very well, predates UK's accession to the European Union, significant advances in judicial review since then. There's been judicial endorsements of common law constitutional rights and more direct application of principles contained in the ECHR. So the Matthews case that's the big point. If you want to have go back to reason, obliged for a reason, Matthews case is the single biggest reason that perhaps can underpin the convention these days. If the UK says, we actually have this power to legislate for you, and we're going to use this power to legislate for you, whether you like it or not, whether it hurts you or not, then it's quite possible to say, well, in that case, you are not complying with the European Convention on the right to vote. Of course, it's a very dangerous argument to run, for a very simple reason that the UK could then reply and say, well, then we'll give you the right to vote in parliamentary elections. And that obviously would be the absolute death of constitutional autonomy.
Why was the Gibraltar government incentivized to actually push that envelope when they were putting this in that executive? I would have thought that same logic applied in their relationship.
Well, I think because they wanted to have people in the European Parliament to represent them on matters of European interest. They didn't want members of the UK Parliament, or I suppose they could just about be comparable in size to the smallest Scottish constituency, for example. But they didn't want to have one Gibraltar constituency and therefore legitimise the use of UK power on all aspects of Gibraltar. In actual fact, if they were to become a highly devolved part of the United Kingdom, it would kill stone dead the Spanish arguments for why Gibraltar is different to the Spanish territories which sit on the edge of Morocco, and why they are totally different and nothing at all like UK holding the territory off the coast of Spain. But they don't want that. It was just about getting a seat in the European Parliament, which is a far more limited matter. There were arguments at the end of the war, certainly in Jersey, I don't know if they exist in Guernsey. There were those who thought that Jersey should become a county in England with representation in Parliament. But obviously, that again, you lose your autonomy. You decide you're going to become part of England. You are Cornwall, basically. And we wouldn't necessarily be here having this discussion because probably the whole of law, or Guernsey law would have died at that particular point. Although, on the other hand, it would probably just be a small farming and tourist community with the DDP per head of the Isle of Sheppey. So, Jowl also argued that constitutional conventions could solidify into law. That was based on certain lines of authority in Canada, which obviously I'm not going to ask Lauren about. And but you can almost forget about that, just to because the Miller case basically knocked that idea on the head when the SNP tried to turn its conventions into solid law. And also point out that supremacy of Parliament is related to the separation of powers and supremacy over the Crown. It's not really about the supremacy over different territories. Which rather, of course, raises the question of where does the supremacy of Parliament over Jersey come from? Parliamentary sovereignty really comes into its own in the 1690s and thereafter, because Parliament can now, with an Act of Parliament, become supreme over the Crown. Post-Kilburn. First, it's me. Good. 2017 JGLR argued in support of JAL. Well worth reading. Parliamentary sovereignty, where does it come from? Because it's all very well the Attorney General in 1689 or the Privy Council in the 18th century asserting that parliamentary sovereignty definitely applies over Jersey and Guernsey. But Parliament is the Queen in Parliament, it's Queen, Lords and Commons. And those aren't our Lords and they aren't our Commons. It just so happens to be our Queen, albeit arguably in a slightly different capacity. So where does parliamentary sovereignty really come from? Well, from a UK English perspective, because actually it becomes very difficult if you start thinking about Scotland, so if we won't forget about Scotland for a moment. So it comes from common law. There are some who will say that parliamentary sovereignty is a common law concept, a creation of common law. That's said by Baroness Hale and Lord Hope and Lord Stane in a case called Jackson to do with hunting. That's all very well, but if it comes from the common law, what is one thing we know about the common law's relationship with Guernsey? Doesn't run to Guernsey. So how can, if it's common law, how can it apply to Guernsey? Secondly, popular sovereignty. This is even easier to run as an objection to the paramount power of Parliament. Popular sovereignty, well, the populace is the UK populace, and it doesn't include the populace of Guernsey. Therefore, parliamentary sovereignty cannot run to Guernsey. Argument number two, it's doing well, doing well. Third one's trickier. And this is William Wade's argument for the origins of parliamentary sovereignty, is it comes from political facts, which basically comes down, as I see it, that if there was any fight within the UK body politic between the power of Parliament and the power of anybody else, Parliament wins.
Wow.
Because it has the people, it has the army, it has the legitimacy. Let's say, for example, let's say if in the if the Queen was to decide that she was going to dismiss the government and appoint her own government, and say, well, I've got enough tax money to run for a year, so I can do that. Don't need any new. I don't need any new laws. There are far too many new laws getting passed, don't we? Well, she's going to set herself up to a fight eventually with Parliament, because when she has to come back to Parliament for money at some point, and Parliament will win. Parliament will depose her. So, on this view, what you have is, well, the Channel Islands knuckled down to the supremacy of Parliament because it had the greater, it would win any fight. If we wanted to say no to Parliament passing these acts, then we would destroy the relationship, and that was something we didn't want to have. Or alternatively, in reality, it could invade, could authorize an invasion, and it would win. So best just to say, yeah, we accept your power, please don't use it. So maybe the political fact is that if we don't accept the supremacy of Parliament, we have to become independent. And how do we do that if the UK doesn't recognise our independence? We become Catalans, and we all run off to Belgium to hide.
But this is all theoretical because it's not been tested.
It's not been tested.
That's like an embrace, isn't it? Of two sides.
Yes.
It's like with the AML law that they tried.
Hmm.
Have they been successful? They were ordered Guernsey to register that in the law. Guernsey could have refused.
Hmm.
And given the turmoil in Parliament today, Brexit, it could have just kind of fizzled out.
Well, you then get the UK try and enforce it. And how do they enforce it? Well, I suppose they might try and order the Royal Court to register it, and if the Royal Court refused, you then appeal to the Court of Appeal, you then appeal to the Privy Council. The Privy Council is comprised of UK lawyers and who are very much schooled in the supremacy of Parliament in these regards. Maybe in a fully argued case, they'll take a different approach. Alternatively, the UK declares that there's a good government has broken down because of what was being done, and it purports to send commissioners in to take over from the local government. And you have the same potential issue that the Catalan civil servants had. Who do you recognise? And which the answer is, well, which one is most likely to take away your money and your pension? Who do you think is going to win? So that's, the several layers down, there's the potential for that sort of confrontation. Now, the next one, Guernsey, this was quite high up. The UN list of non-self-governing territories was something which was used a lot in our UEFA application. Obviously, it couldn't really get us as far as we wanted to there. But the UN has had since after the Second World War a list of non-self-governing territories. So these are basically colonies. Jersey, Guernsey, the Isle of Man are not on that list. Nor is Puerto Rico for some reason. It was taken off the list, but I think that was a bit dodgy. But Jersey, Guernsey, and Isle of Man have never been on that list. If you go to there's a US State Department list of non-self-governing territories, and it puts who is the sovereign territory for all of them. But Jersey, Guernsey, and the Isle of Man, it puts down basically a bit complicated. Because we're not non-self-governing, we are self-governing because no one else has a constitutional right to exercise the government of Jersey, Guernsey, the Isle of Man, the Crown Dependencies, particularly the two Channel Islands, because I think the Isle of Man, there may be some differences in the deep magic of their constitution. Now, an aggressive response to the Sanctions and Anti-Money Laundering Bill would be to say, well, that's all very well, UK. Now, could you please put us on the UN list of non-self-governing territories? Because if you use that power, then we are not a self-governing territory. If you say that you can constitutionally use that power, we are not a self-governing territory. Now, very aggressive. Why is it very aggressive? Because if you go on that list, it triggers an obligation of decolonization. So the argument here is that the very act of the UK using its authority triggers an obligation to remove that authority, to decolonize. So maybe begin to edge, if you actually really started to put that in play, you edge towards that, because there's one thing no one wants to do these days in the nice cozy world of liberal democracies, is to actually colonize something. Well, unless you're the European Union, that doesn't matter. And then there's the Sir Michael Burt article, which is probably more worth citing because it's Sir Michael Burt. And he argued that orders in council should be reviewable in the Channel Islands courts. And this is logical, that we have the position where the UK has recognised that its courts can review the legality and reasonableness of orders in council that affect overseas territories. Well, why shouldn't the local courts in Jersey and Guernsey have a power to review orders in council, which are ultimately orders of the Privy Council of the Queen as in right for Guernsey? Why isn't the correct court to review them the Channel Islands? And it would seem to logically flow from the Barclay decision that must be right. It may well also be reviewable in the English courts, but the court which primarily has interest is in Jersey and Guernsey. Now, I am running very badly behind, I think, but that is 12 o'clock. So if we want to, how long do we need for lunch? Need half an hour. If you need half an hour, because Liz is coming back at 1. If we could just have half an hour, then we can get cracking and hopefully get to the end of these slides. Okay. That means you stay. If you're only having half an hour and coming back at 1 o'clock, it's 12 o'clock at the moment. No, sorry. Okay. Extension of Acts of Parliament. This is Philip Johnson's point. It's one of the other articles that I gave, and it comes back to that here. The question is actually asking is, well, what is the actual status of the ordinary extended act of Parliament? Is it an order in council? Is it delegated legislation? Delegated parliamentary legislation? And it's not clear. Now, this is at the bottom of that slide is a point which I make, which is if we deal with the question of the power of Parliament to say the Channel Islands do this, just quite simply do this, which is that it's now become a cardinal point of British constitutional law that statutes are read down so as not to conflict with fundamental constitutional principles unless they really, really demand it, which is basically to say that you really have to say, we intend to abrogate legal professional privilege. If you take the Morgan Grenfell case, we intend to give you the power to act contrary to violate prisoner correspondence with their lawyers in the Sims case. So if Parliament says this act shall take effect in Jersey and Guernsey, or take effect in Guernsey, we're interested in, is it actually saying it should take effect regardless of registration? Well, it hasn't made it clear. But it needs to, if it wants to say this takes effect in Guernsey, whether or without consent, without registration, contrary to those fundamental principles of the constitutional relationship, contrary to fundamental principles of democracy, contrary to fundamental principles of the Matthews case and the European Convention. If it wants to say that, if it has the paramount power, it can, but it needs to say it, and it needs to say it in terms. And what chance is there of someone wanting to pass an act of Parliament which actually is so in your face, we are going to violate democratic principles on this one? It's greatly reduced because people tend not to want to say things like that. So that's, again, it's an untested argument. It's in my 2017 article, so it's quite legitimate to mention that. Again, under Crown or Parliament, and this is one of Jowell's points. The only proper historical relationship of authority that can be shown that links Guernsey to the United Kingdom is the relationship with the Crown. There's no historical link to Parliament. Parliament obviously has the power to control the Crown within its own jurisdiction. So if it gives an instruction to Privy Councillors to do something in London, which is where they're based, then they have to do it. But that's an entirely different matter to whether or not the Guernsey courts and the Guernsey authorities have to recognise that. Which perhaps comes back to my earlier point that perhaps key to the whole authority of the UK over the Channel Islands is that the UK authorities, particularly within the executive, but also Parliament as a whole, are well placed to control the Crown, whereas it does not, as is the case with independent members of the Commonwealth who retain the Crown, act on the advice of our local governments. That slide's got a little bit mixed up. Okay. Yeah. The Barclay case, we lack Gordon, or he will be able to tell us more, and that was get a little irritated with me. The arguments by the Barclay case was basically part of the interminable Barclay legislation against SARC. And their claim was that the new SARC constitution violated human rights in various ways, and so royal assent should not be given. Again, if we get back to the difference between how the royal prerogative I think I gave some new slides, and I gave directions for them to be printed up again, and if that hasn't happened, I'm sorry. Okay. Okay, so this is the.
I think these are the ones that we got in time.
Okay, hopefully.
Yeah.
Because if you have, there's a particularly embarrassing typo about sort of Peter Port at one of the late ones, so I hope that. Yeah. On the site now, it should be the updated versions. It was on Friday morning that I sent the new ones, new revisions through. Okay. Anyway, suffice to say, make sure that the handouts are all properly revised and everything. And actually, I might add to them because some of the stuff that's come up. This one has been very, very useful. So the argument by the Barclay case is essentially a challenge to the use of the royal assent to insular legislation, in that case constitutional legislation, but to come back to the idea about what is one of the differences between how the royal prerogative operates in the Channel Islands as opposed to England and Wales. In England, in the United Kingdom, there's no decision to be made about the grant of the royal assent to legislation. It has to be done. For UK Acts of Parliament, it just has to be done. There is no possibility of going to court to try and restrain the grant of royal assent, or to say the government of the day should not advise the giving of royal assent. The government of the day doesn't advise royal assent. It's just a mechanical process. Whereas because you have that step of the UK government vetting project de loi that come from the Channel Islands, there is a possibility, it becomes respectable to argue actually royal assent should be withheld. there is a jurisdiction to do so. So the question is, first question, that the courts in England and Wales shouldn't have that jurisdiction to actually review the royal assent, the giving the royal assent at all, because it's not an English and Welsh matter. Something that had gone by on the nod in the previous Barclay case. And if they do have legislation, have jurisdiction, it should not be used in that case. Now, what happened in the case is that it got to half-time, and the Supreme Court said to the representatives of the islands, we don't need to hear from you. Which on the one sense was great, in that they knew when they were going home that they'd won. On the other hand, they didn't actually have a clue what the Supreme Court was actually going to say, because the inconvenient thing was they hadn't had the advantage of the oral arguments of the law officers of the islands. And they hadn't had their own preconceptions tested by being able to put them to the lawyers for the islands, who could then have given a much better reply. So the case was actually decided on the rather narrow point that in this case, it should really have started in the Sark Court and worked its way up to the Privy Council, as opposed to starting in the High Court of the Administrative Division of the High Court of England and Wales. So, well, it's actually entirely unclear when you read the decision and you read the decision again and read it again, exactly what is the dividing line between a case that's appropriate for the English courts and a case that's appropriate for the Sark courts. I think they are a busy court, and I think it's always the case that if one side's arguments are considerably hopeless, that they will decide that actually they don't need to hear from the others. That's the only time it happens. You know, we don't need to hear from you, we've already decided. It was unfortunate in this particular case because the grounds on which you are going to decide it were quite important. But if you are the law officers of Jersey and Guernsey, what exactly do you say in that position? You're going to rule in our favour. I'd like to give you some reasons why you might decide that it's not a good idea. Because the only thing, because if you insist on having your say, you give the other side a right of reply, and the only thing, and your main risk is you might sink yourself. So it was unfortunate to that degree. It would have been much better if they had just gone out, sniggered a little bit, and then said, "Okay, come on, let's hear from you why we're right." Okay, that would have been much better. Now, so what Baroness Hale said is that as the UK has continuing responsibility for the international relations of the bailiwick, and they have political accountability in that extent to the United Kingdom Parliament, hence, royal prerogative being used on the advice effectively of the UK government, albeit through the Privy Council. UK government is accountable to the UK Parliament. The actual line of accountability for the advice given and the use of the royal prerogative politically goes back to the UK Parliament. So why not legally to the courts of the United Kingdom? But only in an appropriate case.
Is the principal point taken by article number 1 is that where you want to review the decision to royal assent, which is part in the
Yeah.
anything else of importance?
So
Anything else of note? Because those decisions are quite difficult to really take the points that you should from. for the purposes of this course, that's the principal point.
Yeah,
From
so
Barclays number one.
essentially they upheld the rights, they upheld the concept that the right of the Crown to refuse royal assent. That's implicit in it. They endorse the idea of the paramount power of Parliament. They say, well, we dealt with this in a case called Lardner-Burke to do with South Rhodesia, declaring UDI in the 1960s. Well, South Rhodesia was a colony. Although it had been granted immense autonomy, the actual legal relationship had never been severed, so it's a very different case, as Darrell points out. And he said that if refusing royal assent could be challenged, which we undoubtedly would argue, so if you had a refusal of royal assent, we would definitely, I think, want to turn up in the English courts to argue that that was not allowed. So they said, well, if a refusal of royal assent is challengeable in courts, then surely the grant of royal assent should be challengeable in courts. Now, the difficulty with the latter point, and I had considerable discussions with Gordon on this particular subject, is that whereas it's obvious to see the grounds of challenge of a refusal of royal assent, it's very difficult to see what the real grounds of challenge to the grant of royal assent. Because if the challenge is based on this particular law violates the European Convention on Human Rights, it's a state matter whether to violate the European Convention on Human Rights. It's a state matter whether or not you're going to take a particular view that you can get away with not complying with a particular international treaty. If, as happened in the Communications Act of 2004, the Parliament passes an Act of Parliament saying, we don't know if this is compliant with the European Convention. We think it should be compliant with the European Convention. We will argue it's compliant with the European Convention, and we'll probably change it if we lose. To take that particular view is open to Parliament, and it's open as regards Guernsey to take that view as regards Guernsey legislation, but the decision to do so is not really a justiciable decision. So it's very difficult to see what actual grounds you could take before that could really win, that would deny lead to a denial of royal assent, particularly as the human rights Bailiffs Paper Guernsey law has exactly the same scheme as the Human Rights Act in the UK, which specifically permits legislation to be passed, which is contrary to the European Convention. It's a political decision whether to go ahead with that particular fight. So how do you challenge in the courts whether or not that fight should be taken or not taken? I can't see how it can be done. Anyway, independence for Guernsey. Not really a Guernsey issue, as largely a Jersey issue. It gets raised every now and then in our papers, and although Philip Balash is not actually as keen a supporter of it as many people take him to, so suggestions have tended to come from him as to that we should consider the possibility in the right circumstances. But the view, and for your purposes, the Guernsey Constitution Advisory Panel, the loss of the advantages of the relationship with the UK would be too great. Defence would no longer be guaranteed. Common travel area and immigration status would be imperiled. The British passport is a good passport to travel the world on. A Guernsey passport would carry much less clout. We had somebody who from St. Lucia, and she came over to law drafting for 5 years specifically so that because she had a British passport, her children didn't. They didn't want to live in the UK for the rest of their lives. They actually wanted to go back to St. Lucia. But having a British passport is extremely useful for travel and international purposes. And also, you'd find yourself negotiating on your own, which is quite possibly going to be a worse position than having the UK looking out for you in a rough already capacity. And would you still be able to rely on existing treaties? So dispute resolution, at the moment, all looking a little bit ropey, it has to be said. It really was very much down to the wire whether or not the sanctions and anti-money laundering bill would have been forced on the Channel Islands in its original condition. Moving briefly, making treaties. Treaties are a state matter. You have to be a sovereign state to make treaties. Being recognised as being allowed to make treaties is what makes you a sovereign state in international law. There are three grounds, I think, for being state: as permanent territory, permanent population, and international recognition. And the one thing that the Channel Islands don't have is the latter. So it doesn't matter that, in actual fact, the Channel Islands have more domestic autonomy than the core member states of the European Union. They're not sovereign because they lack that capacity to basically wage war on other countries and sign treaties on nuclear arms and stuff like that. Of course, many of the European Union countries are themselves limited in what they can enter treaties into. So, when it comes to treaties proper, Guernsey is represented by the United Kingdom, and the key phrase in international law is about representing the international relations of a territory. There used to be a whole list: colony, protectorate, other such relationships, and now it's just talked generically in terms of representing the international relations, which means they can sign on our behalf without our consent as a matter of international law. But Guernsey, like the United Kingdom, is a dualist country, which basically means that when you sign a treaty, it has no effect in domestic law until you enact it. And herein lies the whole problem, which is that, or not the whole problem, but most of the problem, which is that the UK can promise on Guernsey's behalf that a particular thing will become law in Guernsey. It can bind itself in respect of Guernsey in international law, even in matters where it doesn't really have the constitutional right to legislate. And in any case, legislation is required. So even when, for example, in extradition, there is an order in council to make the extradition, the old Extradition Act of England and Wales, to continue it as being a law recognised as a Guernsey law, in order in council to convert it into a Guernsey law.
What's the effect then, Guernsey, if the UK signs a law on behalf of Guernsey, or which includes Guernsey,
Yeah.
and then the Guernsey doesn't make any equivalent legislation?
Well, then the UK will be non-compliant. So, for example, if you have the let's say it's quite fashionable at the moment, so we should implement the UN Convention on the Rights of the Child. It's a very vague convention. But let's say the UK signs that, and it signs it on Guernsey's behalf. Okay, I think it is actually applicable in Guernsey, but then if it's not legislated for in Guernsey, then Guernsey places the UK in non-compliance with it, and the UN committee and commissioners who are responsible for that may then say the UK is not complying because Guernsey does not have this, that, and the other. And the UK will then say, this is very bad, Guernsey. You are not complying with your international obligations, and you're putting us in non-compliance. Now, if that was something that Guernsey never wanted to sign up to, it might say, well, isn't that a bit of nonsense, really? You're basically saying that we are in violation of something because you told us to do it. And now, which is the next stage, you're saying you have the legislative power to force us to do it because you promised that we would do it. It's circular, it's bootstrap. And it becomes a particular problem because more and more in the world, civil servants head off and junior ministers head off to junkets and sign up to things which are very vague, very aspirational, and are to do with classic internal affairs. Now, usually speaking, the Crown dependencies should be left out of it until specifically included. If you read the extradition legislation, extradition treaties, they've said for almost since the start of having extradition treaties that they only apply to Crown dependencies, colonies, overseas territories, however called, if an arrangement is entered into with the local authorities or with the consent of the local authorities when they agree with it. So, international affairs, Guernsey, part of the United Kingdom for the purposes of international law, which basically means that the rest of the world doesn't have to worry about anything that I've said today. It doesn't have to worry about any of the internal mechanics. If the UK pledges Guernsey's, the UK says it applies to Guernsey, as far as they're concerned, the UK has authority to do that. Obviously, very inconvenient. And the UK in 1950, the Bevin Dispatch, saying that actually normally Guernsey wouldn't be bound, that it's not actually included. When we talk about the United Kingdom, this doesn't include Guernsey, or Jersey, or the Isle of Man, or indeed any overseas territory. They're only involved in this if we actually say it, because at this point, even what were still colonies were getting more local autonomy. So the idea of using international law to dictate to them was becoming a bad thing, viewed from that perspective. However, at the same time, in other parts of the world, they were saying this is all terribly bad, excluding these people from the benefit of international law. We don't like the fact that the Spanish and the Portuguese are excluding their colonies from the benefit of international law, just so that they can behave in a tyrannical fashion. Where it has got to at the moment is its established practice for the UK to put in reservations, and that's accepted by the UN. Because it's accepted that there isn't a bad reason, there's actually a good reason. It's actually a very democratic reason for not trying to force rules on territories that don't actually want it. Not every convention is a major human rights convention that ought to have universal applicability. Now, in the Kilbrandon, Jersey challenged the right of the UK to make treaties without consent, but the UK basically wasn't having it. The most it was willing to say, the Home Office, was there should be improved notification procedures. Because in the end, fundamentally, the UK can't get Jersey's consent for everything, or Guernsey's consent for everything. It can take notice of the island's own domestic concerns. But if it signs up to a new international standard with the OECD and makes something an international standard, it will effectively be forcing this on Jersey and Guernsey, whatever derogations might be put in. And it can take into account the interests of the Channel Islands, but it's not going to be bound by them. It's going to be looking at broader interests. And of course, it wasn't at the time of Kilbrandon even the case that in Jersey, which took a stronger line in Guernsey, that there was clearly one view on the subject, because as we've been saying, there's often been those who wanted to involve the UK in local affairs, and so it was in Jersey, the Jersey Democratic Movement and the TGW wanted the UK involved, probably because they didn't trust local politicians. This slide deals with what we just described about the bootstrapping that is inherent in what Baroness Hale says in Berkeley, that the UK can validate what would otherwise be unconstitutional legislative power by using its constitutional power in relation to international affairs to enter into an international agreement to use its legislative power. So the one final, just to use the last minute or two, or overrun by slightly more, there's now entrustment, particularly in tax areas where Guernsey is allowed to enter into its own agreements. And ultimately, there's no real difference between these and treaties, except one of them nomenclature, because a treaty is ultimately only binding in good faith. And when Guernsey is allowed to sign something with another territory, another country, it's still binding in good faith on Guernsey in the same way that a treaty is classically in international law. If Guernsey signs an investment agreement with one of the Gulf states, then it has to comply with that or lose its reputation for trustworthiness that is vital for it to be able to sign any agreement. And finally, Guernsey and Moneyval, OECD and Moneyval, Guernsey is often a separate member or treated as a separate member in many of the main committees of these organisations. So in Moneyval, Council of Europe's Moneyval, Jersey and Guernsey conduct peer reviews on other countries, territories, has peer reviews conducted on its affairs. No different to it would be if it was a sovereign country. And finally, there's the framework agreement, which is there, but it doesn't actually bind the UK to do anything, and indeed, quite famously, entirely contrary to the principles of entrustment, the UK refused to let the Crown Dependencies sign a FATCA agreement with the US until we agreed to sign a similar agreement with the UK when the UK wanted it for its own domestic purposes. And the UK said, well, we can't, it would be really bad and against any sort of constitutional principle if you had a closer relationship with the US than you had with us. That was really a fairly facile argument. It was just a pure use of the naked power of being able to decline entrustment. Okay, and I think we can stop there, and we'll be back at 5 minutes past 1.